I am Ricky Ott, Director of Ultimate Civics, a project of Earth Island Institute. Welcome to Ultimate Civics, lessons on foundational civics instruction for our classrooms and our communities. This instruction is intended as a guide to use the free lesson materials posted here. In Lesson 6, we explore a game-changing action in real time. How to use our constitutional rights to limit the power of government and defend what we love. Part 1 examines the constitutional rights cases, trial proceedings, and legal concepts like standing. Our essential questions for this part are: what are constitutional rights cases? What are elements of a court case? What is legal standing and why is it important? What we're going to be talking about are constitutional rights cases, and we will be using the youth climate cases as real-time examples. So constitutional rights cases can be potential game changers. But why the judiciary? Let's start there. The federal youth who are suing the government have decided that this has been going on for over 50 years with different Congresses and different presidents. They knew of the danger and they knowingly allowed that danger to happen. The danger being that burning of fossil fuels has increased carbon dioxide in our atmosphere to levels that have destabilized our climate system and also polluted our atmosphere. So if what the youth are suing about is claiming harm from the federal government's actions, that this was never stopped and the harm has built to where it's actually an endangerment to their generation. If the court agrees with the youth that more constitutional rights are needed to protect people from this danger, then this case has the potential to change the way we think and act in our society. The youth are bringing this case as a last resort, meaning that the other two branches are not taking action to stop the harm that has built up over the past 50 years. So meet the youth that are taking these cases to court. First, we're going to talk about protecting our constitutional rights. Why the judiciary? One other pass at this. Now, remember in Lesson 3, we talked about the legal framework that underpins our government and that all of our branches can actually make law. Part of the problem here is that the legislative branch makes statutory law, the executive branch makes administrative law, and both of these laws are based on one case at a time, one law, one rule. So by challenging the legislative branch or the executive branch, acts of Congress or rules, you can only challenge one rule at a time. Under the judiciary, we have common law. And common law allows people to bring cases when one single law isn't enough, when all the polluters and pollution is adding up, and it's a system problem. So common law challenges through the judiciary allow people to register a complaint that the whole system of laws and permits, in this case, need to be changed to ratchet down the greenhouse gas emissions. Now let's meet our climate youth that are challenging the governments. So there are 21 in the federal case, and at the time this was filed in 2015, they were all between the age of 8 and 18 years old. These youth are plaintiffs, which is to say that they are the persons claiming to have suffered harm caused by actions of another. The person accused of causing the harm is the defendant. And the case is named, here you see it, Juliana versus US, after the lead plaintiff, in this case, Kelsey Juliana, here, and after the defendants, the US government. Our Children's Trust is a small group in Eugene, Oregon, and they are coordinating these youth-driven legal cases and actions in all 50 states, against our federal government, and also in 13 countries. So what we're familiar with probably when we think of a trial and what it is bringing something to a court are those trial scenes in TV shows and movies where lawyers for the plaintiffs and lawyers for the defendants argue in a court before a judge and sometimes a jury, and they present their evidence in a court of law. But there are important parts of a trial that actually happen before and after the public court scene. So what we're going to do is have a look, as in our small group activities, have a look at the vocabulary for these words: remedy, complaint, standing, and decision. And then you decide in your small groups which of these four things happen before trial or after trial. We know that trial happens third. What happens before and after? What happens first and last? So have a look at the vocab, decide, and then the table groups, the small groups, present their findings. And pretty much what's happened here is that the complaint is something that the plaintiffs have to file to start a case. No complaint, no case. It's pretty much that easy. With standing, standing is, we've talked about that in past cases, and what that is about is it's the ability to come and bring a case to a court of law. So they have to pass that hurdle as well. Then they can go to trial. After trial, during the trial, there are decisions that are made. And those decisions are either the cases, the points are valid or not. If the points are valid of the plaintiffs and the court decides there is harm, then there will be remedies. And those all happen well after the public trial. So the remedy is the fix for the harm. No, if the judge decides with the plaintiffs, then there is no harm and there is no remedy, so it's over. So we're going to focus now on the pretrial activities. It's important to realize that not all cases go to trial. There are actually 3 requirements or hurdles in order for a judge to accept a case in a trial. The first one is that the plaintiffs have to demonstrate that there is actually personal harm, that they have been, and that personal harm has been caused by the defendant's actions. So that's the second hurdle. Did the defendants actually cause the harm? The third one is, can the court actually remedy the harm? If the court can't do anything, then there's no point in having a hearing and a trial. So those are the 3 hurdles that have to be overcome by the youth plaintiffs in order to proceed and go on to an actual trial with the facts, where the facts are weighed by the judge. What we're going to do now is a small group activity, and what it's about, it's a role play. And it's to learn how the youth plaintiffs actually proved that they had standing. So everyone has a statement of standing for one of these 8 plaintiffs shown on the screen. The statements were adopted from the original complaint in Juliana versus US. The paragraph numbers in the complaint, in the statements, match those in the original source. So for example, everybody is going to be doing is reading who they are. They are a plaintiff now. So they're going to read their statement of standing to themselves and find 4 personal values that their plaintiff claimed was harmed, and then what was the cause, the claimed cause of the harm. And you have about 5 minutes to do that analysis, and then everybody will find 2 other plaintiffs and share those values and the harm. Then we come back for a group discussion. So the way we're going to do this today is I'm going to give an example. Just for example, before everybody cuts loose is, for example, Jaden here. Her home was damaged from more and more severe storms caused by actions of the plaintiffs, more carbon dioxide in the atmosphere destabilizing things. So she loves her home, and the harm claimed is that it's being damaged by more and more severe storms. That's an example. So what we're going to do is now go to there, and I just have selected one paragraph from 4 different plaintiffs, just so you can kind of get a feel for what these complaints actually look like or sound like. And as I read this, listen for the personal values, listen for the harm. When we finish all 4, we'll come back to a discussion. Jamie grew up on the Navajo Nation reservation in Arizona. In 2012, Jamie and her mother had to move to Flagstaff because the springs they once depended on year-round are drying up. They can't afford to haul water for themselves and their animals. Now let's go to Zealand in Oregon. Zealand, on his complaint, says that due to warmer winters and decreased snowpack levels in Oregon, Zealand was unable to ski and his mother was unable to work at the ski resort. Decreased snowpack levels will also limit drinking water for Zealand's family and community, as Eugene's only water source, the Mackenzie River, is fed by melting snowpack. Our next plaintiffs are Isaac, also in Oregon. Since he was very young, Isaac has had asthma. Isaac's asthma is worsening and will continue to worsen from air pollen due to increased pollen counts and smoke from wildfires. Isaac enjoys athletic activities like hiking and soccer. Increased temperatures will worsen his asthma and make him less likely to play sports. And we have Journey in Hawaii. Journey's food security and his enjoyment of coral reefs and sea life are harmed by climate change impacts, such as ocean acidification, sea level rise, increased sea surface temperature, changes in ocean circulation, and increased storm intensity. So here are our 4 types of wealth, which we covered in lesson 2. And let's think about now what we all heard. And of course, there's 4 other plaintiffs, and I'm going to summarize each of these 4 types of wealth. So for economic wealth, what we hear are property or homes are being devaluated or lost from violent storms and rising seas. It was more than just Jaden's home. Also, there's economic harm from relocation because of drought or forest fires or drying up water sources, which affect food crops. Some of our youth plaintiffs are farmers, and some are gardeners, so they're either growing food for their own personal use, and that's an economic value. Looking at the environment, we have extended droughts, more and more intense forest fires, more and more intense storms, dying fish from the rising temperatures, coral reefs loss from ocean acidification, melting and disappearing snowpacks, and disappearing water supplies. As for social wealth, about half of the plaintiffs are actually suffering asthma or respiratory problems from burning forest fires, increased pollen in the air due to the warming temperatures. They also are all pretty much having a limited opportunity to recreate outdoors because in the summer, the weather's too hot and there's too much pollen and there's smoke, and in the winter, there's a lot of snow loss, and that just is affecting outdoor activities. So that's standing, and the last part of this is a reflection and then a partner activity where I ask, do you have anything in common with the plaintiffs? Because we've just had this huge, rich discussion. And turn to a partner and share. That's a pretty rich discussion as well. And coming out of that, what I like to ask is, who had something in common with the plaintiffs? And pretty much everybody raises their hand. And that is a really powerful moment to look around the room and see that, wow, this is in some way affecting all of us. So the status of this case right now is, even though it started in 2015 with the complaint, it has gone pretty much nowhere towards trial, towards actual trial. Because even though the courts granted standing, as you might assume they would from those powerful statements, the federal government challenged this right from the get-go. So first it was the Obama administration initially, and 650 oil and gas companies and manufacturers that intervened. So the court allows interveners on either side, plaintiffs or defendants, if there's an economic harm or basically standing. So 650 oil companies were talking about, this is going to shift our wealth and our economic gain here if the plaintiffs prevail. So 21 youth against 650 oil companies and the US government. It was pretty remarkable. Still, the lower courts granted standing. Well, then we had a presidential election, and we've got the Trump administration took office in January of 2017. Things changed. All 650 oil company interveners dropped out. And over the next 2 years, the federal government has asked the higher courts, meaning the appeals court and the Supreme Court, which are over the district court, 5 times to order the lower court to drop this case. The federal government's main reason is that it belongs in administrative law. It belongs in the executive branch. But as we know, that's one law, one rule, and that's not going to cut it. That's not what's happening. We have a system-wide problem here, global warming, okay? What's happened is there was a pre-trial hearing of the last request. It was granted to the government. There was a pre-trial hearing in June, and we are still awaiting the outcome of that hearing. At this point, the youth are joking that when they started in 2015, the media called them the climate kids, and now the media is calling them the climate youth. And before they get done with this case, the media might be calling them the climate adults. So the Trump administration has successfully stalled this case. It has been stalled for 4 years now combined. 2 administrations have stalled this case. So this completes lesson 1. And what's up next? Part 1 of lesson 6. And what's up next is, why does this constitutional rights case so terrify the federal government?